Partnerships and LLCs, are they the magic bullet to help protect whistleblower confidentiality? Hi, this is Tim from thewhistleblowers.com. Whistleblowers or potential whistleblowers often are looking for ways to minimize the risk of illegal retaliation, because although the laws prohibit it, very often companies will retaliate anyway. And one of the best ways to do that is to maintain your confidentiality. And along those lines, whistleblowers often ask, well, how about if I form an LLC, a corporation, or a partnership, and have that entity serve as the whistleblower? Will that do the trick? And the short answer is it's not a magic bullet. It's not perfect. In fact, nothing is perfect, but it can be helpful. But it's important to recognize, number one, that there are limited situations where it will be helpful, and two, that in all events, there are trade-offs, that there are risks that come with using a partnership or a corporate form while you're blowing the whistle. And then again, number three, there is you cannot guarantee anonymity. Some of the programs like the SEC, CFTC, the IRS programs have really strong institutional protections for whistleblowers. And you have a lot of protection, including in some of those you can file anonymously, so that even the government doesn't know your identity until the very end of a successful case. But even in those cases, they're practical things. Companies often can figure it out even if they don't know. And there's human error. Sometimes, courts make mistakes, things get disclosed that shouldn't have. And so in no event, there is never a magic bullet where you can say as a whistleblower that you will never be outed. But there are things you can do to decrease the chances that you will be identified, or certainly that you'll be identified before the case ultimately is resolved. And filing as a partnership or as a corporation is one of the things that can be done. And that being said, thinking about how those corporate structures work gives you some sense of there are limits to how effective they can be, even if everything goes right. Two areas where they are most likely to be effective are if you file a case but the government declines to join it, and you look and say, you know what, without the government, the company committed fraud, but without the government, it doesn't make sense for me to go forward on my own. In a normal False Claims Act case, in most situations, at that point when the case is dismissed, it becomes public, and it is out there on the court records, and even if no one does press about it, it's there to be found, and the company will probably find it, and so your name will be revealed. There are some situations where you can try and get the court to keep it under seal. Those are really tough motions to win. So if you have filed as a partnership or another corporate entity that your name isn't attached to, in those cases where the case is dismissed, the public record, the public document doesn't have your name on it. So that provides you some protection. It is possible that in that situation, a defendant could try and go to court and take legal steps to try and unmask your identity. Different state laws have better and worse protections for that. But you're also dealing with, as a practical matter, does the company want to do that? Do they want to expend their own legal resources? And even if they're willing to, that brings attention to the fact that there was a whistleblower case. And if they don't do that, then they can just say, yeah, there was a case, it was dismissed, there's no merit, and move on. And so filing in a corporate form, in a partnership form, can be helpful there. It's generally not going to be helpful in terms of keeping your identity from the defendants in a case where you win, where there's a settlement and you get money. And the reason for that is, generally speaking, defendants are going to, before they pay you, they're going to want to know who you are, and they're going to want releases. And so whatever the sort of technical legal protections of your confidentiality to get that settlement, probably defendants at least are going to have to find out who you are. And if win, lose, or draw, if after the government makes its intervention decision, if you go into active litigation, it will be tough for you, even with a corporate form or a partnership, to maintain your confidentiality, because in the process of discovery and litigation, there will be conversations about, okay, XYZ company, how did you learn about the fraud? What documents did you have? Where did you get them? Who did you learn it from? And so in that process, it's hard to imagine a place where you can successfully get to the other side of a case, prove up your case without the defendants in discovery being able to figure out who is behind this entity. So ultimately, in that process of discovery, or going back to the situation where there's a settlement and defendants find out who you, the whistleblower, are, there are things you can do to make it so, okay, they know, but they can't just make that public. And even more, if they know, but once the case is settled, again, you have that public document that's out there, and even if the defendants know, if they're not going to do press about it, what is in the public, what people outside of your case can know, is limited. So there are situations where it may not protect you from being retaliated against by defendants or people they know and talk to, but the general public, your name is not going to be out there as a whistleblower, so someone on a Google search wouldn't learn that. So those are the ways that it could be helpful. But in thinking about that and thinking about if that makes sense for you, there are also risks. And a big part about these risks is that a lot of times you cannot really figure out what they are at the time you're filing your case. Some of them you can, but others you can't. So one of the risks, for instance, is there's an aspect of the False Claims Act, the public disclosure bar, that says if there were news or public cases, certain kinds of cases that people knew about the fraud, then your case can be dismissed. And one of the defenses to that, a primary defense, is if you were called an original source. And part of that is you had information about the fraud independent of the public disclosure, and you shared that with the government and things like that. Well, courts have held that if the whistleblower is, for instance, an LLC that was formed around the time the complaint was filed, that corporation can't know anything, have any information that existed before it was formed, or how would it know it? In partnerships, a partnership can be a way to get around that. So you form a partnership and you can form a certain kind of partnership that is really tied to the individual's identity, and therefore you can argue, well, the partnership knew it because it's a product of the individuals. But even then, and again, this is getting kind of technical, but even then, there was a case recently where that happened, and then a variety of steps. One of the partners left the partnership, and then a new one joined, and there was a question of what that meant. And ultimately, the court decided, okay, because of the nature of the partnership law, this individual identity base that gives you a benefit in terms of public disclosure and original source, that law also says when one partner leaves the partnership dissolves. And so now they were litigating the more technical False Claims Act question of the partnership dissolved, so can the new partnership substitute in as the whistleblower to have to file a new case? And ultimately, for a variety of reasons far longer than you want to hear me talk about right now, that because of that corporate form issue and the subsequent facts, the case was dismissed. And so there are those legal issues that while you get some protection, you add some risk. There's also the practical risk that the government, for good or for ill, a number of government attorneys really don't feel comfortable with whistleblowers. They would sometimes call it hiding behind a corporate form or not putting their name on the allegations. The government is going to be investigating this fraud based in large part on your credibility, on their belief that you know what you're talking about and are trying to do the right thing. And there are times when they feel like if you're not willing to put your name out there, then they're not. Maybe they won't take your cases seriously. And I don't think that's fair. I don't think that's right. I don't think it recognizes the reality of retaliation. But it is what it is. And so if you do file with a partnership or a corporate form, you have to think about that consequence. And they're all trade-offs. Going back to the beginning, there is no magic bullet. There's no silver bullet. There's no one-size-fits-all solution. There are things you can do. There are steps you can take to minimize the risk. But it really is all a balancing act, and why it's important to work with your lawyer and be thoughtful throughout the process as you're getting ready to file and when you file. So this has been an overview, information, issues to think about if you're thinking about blowing the whistle. If you'd like to get legal advice, feel free to give me a call for a free confidential discussion